Sorry, whose cell phone is this? No, I don't have no. From where are you?
From 702, out of this news. It's a recording device.
Oh, okay. Thank you.
Judgment in the matters of Thabo Bester versus Netflix South Africa and another case number 2025-147420 and Dr. Nandipha Magudumana versus Storyscope Pty Limited and another case number 2025-16001.
Before me are two urgent applications, one brought by Dr. Nandipha Magudumana and the other by Mr. Thabo Bester. Both bring applications against Netflix International BV, with Ms. Nandipha Magudumana also citing Storyscope Pty Limited as a further respondent. For ease of reference, and with no disrespect intended, I will refer to the two applicants as the doctor and Mr. Bester, and the two respondents individually as well as collectively to as Netflix. There are some differences, but also much overlapping in the grounds sought for the relief against Netflix. In essence, the relief sought is to interdict from screening on the 12th of September the documentary named The Beauty and the Bester, pending hearings of Part B's as set out in the notices of motion. I first deal with the application of the doctor. The relief sought in prayers 2.1 and 2.2 of the notice of motion is an interdict restraining the publishing, streaming, and broadcasting of The Beauty and the Beast on 12 September 2025 in its current form. Netflix must also be compelled to refrain from continuing showing, playing, and flighting the teaser, stroke trail, stroke hook of Mr. Sikeleni's, in brackets the doctor's father's face and his voice until completion of the trial. Furthermore, Netflix must be ordered to take all necessary steps to modify the documentary where Judge Cameron speaks and is shown until the completion of the criminal trial. These orders must be granted pending Part B to be prosecuted. Part B will seek an order declaring the license agreement entered into the doctor and Netflix as unenforceable and unconstitutional, alternatively for the court to give effect to the true intention of the parties. I must from the outset find that there is a total disjunct between Part A and Part B of the notice of motion. Whether the license agreement is set aside has no impact on the prior restraint order, the one being based on contract and the other specifically based on Section 16 of the Constitution. This is already problematic for the doctor's application. The first hurdle the doctor must overcome is whether the matter is in fact urgent. Netflix has argued that the urgency was self-created. In the founding affidavit, the urgency is set out in, and I quote, "The matter is sufficiently urgent to have be enrolled on the urgency that the applicant seeks," close the quote. The historical background set out the timeline, and the doctor did not delay in prosecuting the application. A deadlock between the doctor and Netflix occurred and was only, the deadlock was only reached on the 5th of September 2025. Furthermore, as an incarcerated applicant, the attorney for the doctor, Ms. Reed, experienced challenges in seemingly passing instructions to her attorney. The matter thus could not be placed on the preceding Thursday, and I quote, "But in any event, the investigation of the matter and sourcing of documents went beyond 5 September 2025. The following facts are common cause. On 19 August 2025, Ms. Reid, the attorney of the doctor, received an image of the Beauty and the Bester. On 20 August 2025, Ms. Reid wrote to Netflix. In that letter, she expresses that, and I quote, "As early as January 2025, as soon as our clients became aware of the documentary, which was planned to be aired on Netflix," close the quote. She then repeated the concerns they had, but continues to say, and I quote, "We have since been made aware that Netflix plans to flight this documentary on 12 September 2025, with the trial already being made public." The letter ends with a request to Netflix to suspend airing the documentary. On 20 August 2025, the trailer for the documentary was indeed aired. This is 19 calendar days and 13 core days before the application is launched. On 26 August 2025, ENCA reported that both the applications are to proceed. This is not denied by the doctor in the papers. On Friday, 29 August 2025, a letter dated 28 August 2025 seeks a roundtable meeting. Also on 29/8/2025, Ms. Reid held an interview on ENC, stating that if Netflix did not give them an audience and resolve this outside court, this matter will proceed on an urgent basis to court. On 31 August 2025, Netflix wrote to Ms. Reid that bringing urgent interdictory proceedings would be a patent abuse of court proceedings. She then answers on 2 August 2025 that she needs to consult, this despite her threatening with legal action publicly, seemingly then without prior consultation. Ms. Reid persisted with seeking a round table, despite Netflix on 31 August 2025 making it clear that no round table will be entertained. On 4 September 2025, she again seeks a round table. On 5 September, Ms. Reid sends a draft unsigned notice by email to the attorneys of Netflix. This application is issued by the registrar on the 9th of September, and the notice requires that the respondents by 1700 hours on the 8th of September oppose and to deliver its answering affidavit at 12 o'clock on the 10th of September. The applicant will then reply by midnight on the 10th of September with the matter to be heard on the 11th of September 2025. From the outset, the attorney for the doctor's attitude that a court must entertain a matter on the 11th September, while the answer need only be filed on the 10th of September before midnight, is preposterous. Furthermore, setting out under oath that the investigation of the matter in anyhow went beyond 5 September is a fact under oath, rendering the matter not ripe for hearing a day before the screening. This matter is then proceeded with on the 11th of September 2025 in this division, as instructed by the Acting Deputy Judge President of the Gauteng Division, Johannesburg. The replying affidavit of the doctor is filed on the day of the hearing, with an explanatory affidavit seemingly seeking condonation without any notice of motion. The reason set out for filing the document so late is that the answering affidavit is 60 pages, the delay is not excessive, and the doctor has strong prospects of success in obtaining the relief. No condonation is granted for the late filing of the answering affidavit. The applicant had said the timeline. She cannot now blame Netflix for a comprehensive answering affidavit that they had to compile in absolute haste. Submitting that a replying affidavit can be filed just 2 hours before the hearing as not being excessive is rejected. There are no strong prospects of success on Part A. In any event, the replying affidavit contains new matter, not covered in the founding affidavit, which is trite, is not allowed. Furthermore, submitting under oath that the replying affidavit is compiled by means of improvisation, and I quote, render this affidavit of no value. My decision on urgency. In an urgent application, Rule 6 in brackets 12 of the Uniform Rules of Court require that the applicant shall set forth explicitly the circumstances, what he or she avers renders the matter urgent, and the reasons why he or she claims that he could not be afforded substantial redress at a hearing in due course. As found in the well-known matter of East Rock Trading 7 in brackets Pty Limited versus Eagle Valley, Granite and others in brackets 11/33767 close the brackets, square brackets 2011, ZACPYHC 176, Norchi AJ reiterated the trite principle that the procedure set out in Rule 612 is not there for the mere taking. An applicant must set out explicitly the circumstances which it averred to render the matter urgent. Furthermore, the applicant, most importantly, must state the reasons why substantial redress would not be obtained in a hearing in due course. In the Gauteng Practice Manual, Pretoria, it is set out that the normal times will be abridged and a deviation from Rule 6 will be permitted only where the matter is urgent. The degree of abridgment and deviation must, of course, be commensurate with the case and must be justified in the founding affidavit. I quote, "The degree of relaxation should not be greater than the exigency of the case demands. It must be commensurate therewith. Mere lip service to the requirements of Rule 612 in brackets B will not do, and an applicant must make out a case in the founding affidavit to justify the particular extent at the departure from the norm, which is involved in the time and day for which the matter must be set down. A party must thus set out why the matter was not placed before the Thursday at 12 to be heard the Thursday at 12 to be heard the next Tuesday at 10. Self-created urgency is fatal to an application. Self-created urgency is the urgency which stems from a deliberate inaction until the hour of reckoning. In Commission for the South African Revenue Services versus Hawker Air Services Pty Limited, 2006 in brackets 4, SA 292 in brackets SCA, the Supreme Court of Appeal found that where the application lacks the degree of urgency, the court can decline to exercise its power for that reason alone to hear the matter. I quote, "The appropriate order is generally to strike the application from the roll." Close the quote. The Constitutional Court in A Party and Another versus Minister for Home Affairs and Others, Moloka and Others versus Minister of Home Affairs and Another, 2009 in brackets 3 SA 645 in brackets CC at paragraph 65 found that launching urgent applications on short notice and at the very latest date should be avoided as it places undue pressure on the parties and specifically the court. In the Economic Freedom Fighters and Others versus Chairperson of Powers and Privileges Committee and Others, in brackets 23230/23, close the brackets, 2024, dated 8 February 2024, it was found that where it is expected of a court to digest the contents on a matter on short notice and then expect judgment in the space of a day is wholly unreasonable, and such matter should be struck from the roll. The application for the doctor was set down the day before the streaming of the documentary. This is simply inaction until the hour of reckoning. It is common cause that already on 20 August 2025, the doctor and Ms. Reid knew that the documentary would be screened on 12 September 2025. The trailer was in fact aired on 20 August 2025. This is 19 days, close to 2 weeks in court days before the launching of this application. Even if a court should take into consideration that consultation is difficult with an incarcerated person, she had, according to her affidavit, had telephonic consultations and in-person consultations with the doctor. And Ms. Reid should have obtained the necessary permission to have an in-person consultation with the doctor any day after 20 August 2025. In response to Mrs. Reid's letter dated 29 August 2025, Netflix attorneys advised Ms. Reid that the doctor's demands regarding the documentary are declined. It is also set out in full why a round table will not be held, yet no application is launched. In a letter dated 2 September 2025, the attorneys for Netflix expresses surprise that she has to obtain instructions to bring legal proceedings, as she had already publicly threatened such action, and she could have only have done so had she obtained instructions to do so publicly. Surprisingly, on 4 September 2025, Ms. Reid still persists with requesting a round table. It was quite clear by that time that no round table was to be held. Ms. Reid cannot be applauded for persisting with such request when that request had long been denied. It is trite practice that if an undertaking is sought and not given, or a demand is made and not adhered to, a Rule 612 application must be issued immediately. Furthermore, an opposing party cannot be expected to react to informal notices of motions. This is also not a practice of our courts. The reasons for the delay is without merit, and the urgency is self-created. The replying affidavit and heads were filed on the day of this hearing. This despite the directive of the acting deputy judge present in the Gauteng Division, Johannesburg. This application has not complied with the rules, the practice directives, or the case law, and has placed undue pressure on the parties and the court by bringing it a day before the screening. It was wholly unreasonable. But more importantly, the doctor can obtain substantial redress in due course. Part A is not about media institutions using contractual clauses to divest the doctor of her constitutional rights. That relates to the disjuncted Part B. The right to a fair trial, dignity and equality is the basis for Part A. Substantial redress for all these causes can be found. As stated or as relied on by counsel for the doctor, contrary to what he seems to think the matter says, Kriegler AJ specifically sets out that there are forms of prejudice that affects the right that you are innocent until proven guilty, because doubt will be sown not only on the public but also to the accused's family and friends and colleagues. he finds that this prejudice is unavoidable and unintended byproducts of the criminal justice system. So complaining about this is unfortunately byproducts of the criminal justice system. A defamation claim or a dignity claim can be instituted and damages can be sought. I cannot in any way find that the screening on the three utterances which they find to make the doctor guilty or affects her right to a fair trial has any merit. The matter of media television sets out the interplay of Section 16 with other constitutional rights. The Court of Appeal went as far as to find that prior restraint can only be granted if the prejudice is demonstrable and substantial. There must be a real risk that it will occur. Not one of the phrases relied on can be interpreted as attacking any of the constitutional rights of the doctor. I find that the application is not urgent and it is struck from the roll. A de bonis propriis cost order was sought against Ms. Reed. I have exercised my discretion and the order of costs is as follows. The applicant is to pay the costs on scale C. I reiterate, the application is dismissed. The applicant is to pay the costs on scale C. I now turn to the application of Mr. Bester. Urgency is relied on or is sought to interdict Netflix from broadcasting Beauty and the Bester, pending the declaratory relief in Part B that the documentary violates his constitutional rights to a fair trial, equality and dignity, and his personality rights. Furthermore, that Netflix was not entitled to proceed without his consent or participation. Once again, the first hurdle that the applicant must overcome is that he must make out that the matter is indeed urgent. I do not, for the sake of time, repeat all the case law that I rely on again, as well as the setting out of Rule 612, as I have done in the doctor's matter, but in the written judgment it will be set out. I therefore then turn immediately in applying those principles to what is before me in the Thabo Bester matter. In the founding affidavit, the urgency is set out as that on 20 August 2025, it came to Mr. Bester's attention that Netflix intended to release the trailer on 12 September 2025. He consulted with his attorney, and he again consulted in person with his attorney on the 22nd of August 2025. His lawyer demanded in a letter dated 22 August 2025 that Netflix immediately remove all material, advertisings or references to the documentary from public platforms by 25 August 2025. This engagement continued with Storyscape directly, including the dates of 20, 21 and 26 August, which was not disclosed in the founding affidavit of Mr. Bester. Mr. Bester then launched this application on the 26th of August 2025, setting the date for the 9th of September 2025. Netflix had to oppose by 29 August 2025, and the answering affidavit had to be filed by the 4th of September 2025. The applicant did not comply with the trite lunar furniture matter. First of all, by setting out why he could not comply with the practice directive, that the matter be placed before 12 o'clock on the preceding Thursday to the Tuesday. Nowhere in the application does Mr. Bester expressly address this fact, and furthermore, or more importantly, he does not at all in his application set out why he will not obtain substantial redress. There is not even a single averment in this application setting this out. The quoted case law is clear that this is an absolute requirement, because if substantive redress can be obtained, the urgent application must fail. But in any event, Mr. Bester can obtain substantial redress. Defamation can be sued for. The case law is clear. Furthermore, the right to silence, the right to a fair trial, and the right to be innocent until found guilty is not in any way affected by the utterances referred to. No judge will be influenced by any documentary. Witnesses will be exposed to cross-examination. The public will form an opinion, but that is a byproduct of the criminal justice system and does not affect the rights of Mr. Bester as claimed. The equality issue was not addressed and is simply bad in law. In both matters, information about the doctor and Mr. Bester is firmly in the public domain. In fact, it has been set out in judgments in the bail application and the appeal against the bail, and in the High Court and in the judgment of the Supreme Court of Appeal. Never called by its name by the applicants, but the prior restraint, which is the correct defence, has been addressed by the SCA in the Media Television Pty Limited trading as ETV matter versus the National Director of Public Prosecutions 2007 in brackets 5 SA 540. As already stated, this is the matter that this court must follow. The principle is set out. The court went as far as to say that prior restraint can only be granted if the prejudice is demonstrable and substantial. It is a real risk that it will occur. Speculation, as argued in this court, is not sufficient. I am therefore satisfied that this application too did not comply with Rule 612 in that it did not address substantial redress, and in fact there is substantial redress in due course. For that reason, this matter is also struck from the roll and the applicant is to carry the costs. The court will adjourn.